Hi, everyone. Welcome to the Data Chronicle podcast. I am your host, Scott Loughlin, and co-chair of the Privacy and Cybersecurity practice here at Hogan Lovells. Today, I'm so excited to be joined by Chris Wolf, who is a senior counsel and former partner here at Hogan. He was also the head of the privacy practice at Hogan and one of its co-founders. On top of that, he has been a mentor to many privacy lawyers at Hogan Lovells, including me. Chris, thanks so much for joining. Really appreciate your joining us on the podcast.
Well, it's great to see you again, Scott. Thank you for that lovely introduction.
So, Chris, I think one of the things that we've had many chances to talk about and about your career is that you have really seen the explosion of privacy law and the development of the privacy bar here in this country. I think when you first started, there was no such thing as a privacy lawyer, or at least a lawyer who went by that particular name. And now, fast forward until present day, there are many privacy professionals coming by all sorts of different names, whether that would be lawyer or compliance or cybersecurity. And I think our audience would very much like to hear your perspective about how this whole thing, privacy law, took shape. What were the beginnings of this space, and how did you find your way into it?
Well, some of this may be well known to the audience, but my experience was that in the 60s and 70s, there really wasn't much to privacy law except a lot of, important thinking about it. There were, of course, the Prosser torts, privacy torts, and Alan Weston was one of the great scholars and wrote a lot about privacy, and the Department of Health, Education, and Welfare, now HHS, certainly did some writing about personal rights, personal privacy. But it really wasn't until the 70s and 80s when we finally had some federal legislation. The Fair Credit Reporting Act, of course, in 1970, I think was the sort of the bellwether privacy law that really specified how data on people's credit standing was going to be used, either for credit ratings or for employment. And then there was FERPA and the TCPA, and that brought us up to the 80s when the pace really accelerated. We had HIPAA and COPPA, the Video Privacy Protection Act, Graham-Leach Bliley. And then we get into the 90s and we had the EU Privacy Directive, which kind of threw the gauntlet down for the rest of the world on what was expected, at least in the EU. So that brings me to where I got involved, because for the first 20 years or so of my practice, and I graduated from law school in 1980, I was a generalist litigator. And I used to joke that my tombstone would say he died with his options open, because I did a variety of cases from antitrust to international trade to some employment litigation, you name it. And I had the great good fortune of having an internet-related case that went to trial in San Jose, California, in Silicon Valley. Lasted 3 months. It really involved the backbone to the internet. And this was in 1993, 92, 93. And I came back to Washington and I said, I think this internet's going to be something. And it's before there was any really consumer application to it. And I decided I'm going to be an internet lawyer. And I dubbed myself an internet lawyer. There wasn't much more to it than that. There's no certification or anything. And got to do some internet cases. And then I'll tell you in a second about how I got deeply involved in it. But then obviously I had to focus on privacy. And so I focused on the EU Privacy Directive. I counseled some companies on how to comply with the EU directive. And then the first real momentum began with the first data breach notification laws in California in 2003 and the advent of FTC enforcement actions for unfair and deceptive actions when it came to privacy. And so I think that's when things really got rolling. And at about that time, I got a contract from the Practicing Law Institute to help edit, or to be the editor of its first privacy law treatise. And we had 13 chapters and it ran 1,300 pages. And this was in the early 2000s. You can imagine what it would be today if we tried to put it all in one volume. And so then I think you can fairly say there was an area known as privacy law that one could focus his or her practice on.
Fascinating, Chris. I mean, I think many times that you and I have talked about in the past about continuing to retool yourself as a lawyer, right? Continuing to make sure that you are keeping your skills and your expertise on that cutting edge. And here you were, right, doing that with the internet and the explosion of the internet. How did you, at the time, if you can kind of put yourself back in the early 90s, what were you seeing as the key legal issues that was going to then kind of funnel your practice? Was that privacy, or were there kind of other issues that were really circling around that the dawn of the internet?
So mostly it involved domain name disputes, which seems quaint and arcane right now because the law there is pretty well settled, but also intellectual property. I represent both the Recording Industry Association and the Motion Picture Association, and going after pirates. And that was the era of Napster. That kept us pretty busy. And I can't say that my practice was exclusively internet. I had a case representing all the utilities in the state of Vermont over a crashed set of transmission cables from Montreal to the Vermont border. Nothing to do with the internet, but it paid the bills back then. But that brings me to about 1998, I guess. And I think that's where you were going with your next question, but I'll let you ask it.
Yeah. So interested, right? Because now you mentioned that your tombstone was going to be died with your options open. You, at this point, see that the internet is taking shape. All the legal issues start to come out. You have the option of potentially, going and doing IP litigation. You can kind of do the issues around, pirating, but you choose privacy. Kind of tell me about kind of what that next step looked like and why you focused your career on data protection.
So here's how that happened. And I like to say I was smart enough to be lucky, because it was pure fortuity that I really got into privacy deeply and exclusively for the last part of my career before I retired as a partner. I guess I got to be known a little bit as an internet lawyer. I represented the Washington Post in a case involving the Church of Scientology. And the Post simply reported on what one of the ex-Scientology members had done with the Scientology website. And the Scientologists sued the Post, claiming that that was a copyright infringement. We got summary judgment on that case, but it made some news. And so I was at an event with Mark Rottenberg, who was the founder of the Electronic Privacy Information Center and then its executive director. And we were chatting. And next thing I know, a couple of weeks later, he calls me up and he says, I have an emergency litigation and wondered if you could handle it. This was in January of '98, involving a sailor who was collecting toys for his shipmates. He was a submarinist, actually, or submariner, I guess you would say. And he was collecting toys for his shipmates, and he used his AOL account, which had a fanciful username, which was BYSRCH, which I guess you could pronounce voice search. And his commanding officer said, well, you've now told under Don't Ask, Don't Tell, which was then in effect governing gays in the military, and therefore I'm going to start expulsion proceedings for you. This guy was an 18-year veteran, sole support for his mother, unblemished career. He was out in Hawaii. And so we took the case and went in and got a TRO against the Navy, because what the Navy had done is obtain information to proceed with the expulsion proceeding in violation of the Electronic Communications Privacy Act. They had seen the email, they'd seen the username, but they didn't know exactly who it was. And so they had a paralegal call the general number at AOL and said, we'd like to link this username to a user. Could you tell us who it is? And they did. And of course, the username had been transmitted electronically, and the government can't get electronically transmitted information without proper process, which they didn't use. And so we won that case. And along the way, by the way, Judge Stanley Sporkin wrote a very moving passage about the unfairness of Don't Ask, Don't Tell and the discrimination against gays and lesbians. That policy was eventually repealed under President Obama. Anyway, that case also made the Washington Post. And one of my neighbors read it and called me up and he said, I'm doing a lot of work for AT&T and they're looking for a privacy lawyer. Would you be interested? And I said, absolutely. And so the rest, as they say, is history. And not only did AT&T become a client back then, but I got to know the general counsel pretty well. And we were talking, and he had me do some public policy work in addition on unrelated internet kind of issues. And I said to him, I think a longer term public policy issue for AT&T to be interested in is privacy. And what about forming a think tank on privacy? And he said, sure. And he funded it for a couple of years. And that became the Future Privacy Forum, which I founded and chaired and continue to chair actually to this day.
So, Chris, I'm actually happy that you mentioned the Future of Privacy Forum and your role in creating it and how that kind of came out of that client relationship and the focus on public policy, because one of the things that privacy lawyers today, we are inundated with new privacy laws, and the public policy debate is constantly moving as technology and innovation happens all around us and new technology is created. As you were thinking about how that was going to apply to the privacy debate, what was your kind of initial thoughts on how that was going to develop originally, and have you seen that progress since?
Well, FBFs, Virtual Privacy Forum, has grown beyond my wildest dreams. We now have 50 full-time employees. We have offices in Israel and Brussels and Singapore, as well as in Washington. And Jules Polonetsky, thankfully, remains the executive director. I hired him in 2008, and he stayed to this day. And their workload and the breadth of what they do has expanded enormously, precisely because of what you said. The breadth of issues involving privacy public policy has grown so enormously. We had a very narrow focus to begin with, which was the use of data in advertising, still an issue, obviously, but now we go well beyond that, and as do most practitioners, because you can't exclusively represent a client by telling them about the existing law. You need to tell them about what's on the horizon and what's likely to happen, not only in terms of legislation, but in terms of what the regulators are doing. So that was the initial idea for FBF, to focus on the public policy docket. And it turned out to be a good idea because we are really the only middle-of-the-road organization. We believe in privacy, but we believe in the beneficial use of data for society. And there are organizations on the left and on the right of us, but we are respected by regulators. We have a number of academics who tend to be to the left when it comes to privacy issues. We have consumer advocates as well who sit on our advisory board.
And Chris, you have a perspective on kind of those key moments that really kind of drove forward the privacy policy that developed around the world. During your tenure, I think you've seen a number of those big things happen. Anything jump out to you as those key and pivotal moments?
Well, certainly in the 2000s, the FTC's enforcement actions really accelerated greatly. And they don't like to call it this. They developed a common law of privacy that was used to inform both practitioners and then on to their clients what best practices would be and what to avoid enforcement actions. Then the data breach notification laws, I think, played an enormous role in the growth of the practice and of the industry, because the potential fines and injury to reputation was so enormous. And so those things, I think, in the 2000s were the substantial catalyst for the growth of the practice. And then we saw in the 2010s to this day, the growth of state privacy laws, because still to this day, we don't have an omnibus federal privacy law, which is a big surprise to me. If you had asked me back in the 2000s, would we have a privacy law? I said, yes, eventually. Because you had people like John McCain, who chaired the Commerce Committee, who was in favor of it, as well as Democrats in favor of it. It was a bipartisan issue. I think it still is, but there's such disparity of concerns between industry and consumer advocates that we really can't reach a consensus. And now that the EU has finally given us an adequacy ruling, when was it, just a month or two ago, I think the pressure is off a little bit to do much more at the federal level. And there's such contentiousness in Congress that it's probably still unlikely. So a lot of the action will remain at the state level. And so we continue to have this patchwork quilt with a lot of fraying edges and gaps and inconsistencies and overlaps that makes it really difficult for certainly a generalist practitioner, but for the in-house general counsel to really synthesize all that, which is why I think law practices are going to continue to thrive.
Chris, I want to circle back on something you said earlier, and then just now in talking about those big developments, because one of those things you mentioned earlier was the European Union's adoption of the directive. And then you were leading the privacy practice at the time that the GDPR was released. And we've introduced many privacy lawyers who were still in law school, or those who didn't even go to law school, weren't actually focused on privacy by the time the GDPR was there. I think one of the things that your practice and, the mindset that you had kind of early on in your career and the time that we got to work together was to think globally around legal issues and think globally around how data protection laws would apply between different jurisdictions, which I think was a bit of a novel concept at the time, because many of our legal practices would be rooted in specific jurisdictions. What kind of challenges did you see initially when you were trying to overcome that global nature of the practice?
So a lot of that came to pass because of the combination of Hogan and Hartson and Lovells in 2010. I co-chaired the practice with Marcy Wilder at the time. And she and I both agreed that we ought to take advantage of all the offices. I think it was 41 or 2 at the time. I don't know how many the firm has now. And we convened a kind of privacy summit almost immediately upon the merger and had lawyers from all over Europe come meet with us. And we identified clients who had global presence and that it made sense to offer them all of our services so we could have a coherent, unified approach to their concerns. And the clients found that very, very attractive. They continue to, as you know. And that was a lot of the driver of my involvement and interest in the development of the GDPR and regulations. I testified a number of times in Europe, or at least met with regulators, and had the most astounding experience when I met with the data protection supervisor and one of the data protection authorities and learned that they had never met with a tech company. For some reason, they had it on principle it wasn't a proper thing to do. And I said, well, here's what I'd like you to do. I'd like you to come to Silicon Valley with. Let's go on a tour and let's meet with them. They're not going to bite. And I think it's important for you, first of all, to know that they're human beings. They're not the monsters that a lot of the Europeans have made them out to be. And you need to understand their business. I mean, that's true not only for regulators, but also for privacy lawyers. You need to understand how the data flows work and how they use data and what they do to both administratively and technically to protect the data. And they came, to my great surprise, and spent a couple of days. I don't think it changed the GDPR in any significant way, but I hope it made them more sympathetic to some of the folks in the industry.
It's fascinating. I think one of the points that you have made, I believe you had an op-ed in the Wall Street Journal a couple of years back that talked about how the privacy community was going to need to develop focus areas of expertise. And the areas where it wasn't going to be the case that people can just be generalists in the space that maybe they once were, but instead the space was going to become so specialized that you needed to almost have a major inside of the larger field of data protection. Interested in your thoughts on that and whether you see that as a continuing trend.
Absolutely. I think it's even more of a trend now. While I was a generalist privacy lawyer and I was on the consumer protection side, I would put it, as opposed to the health privacy side. And we make that sort of dichotomy at Hogan Lovells to some extent, although there's a lot of overlap. We got involved in privacy for the connected cars. And now with EVs, there are a lot of connected cars. And very early on, James Denville, now a partner in the firm, who's an associate at the time, and I corralled both of the automaking alliances in the United States that represented all the car companies that sold in the United States except Tesla. And they all sat down with us around a table. Tim Tobin was also involved for months. And we hammered out a code of conduct that to this date they still follow. And that's enforceable by the FTC and states because they're made representations that they have to adhere to. And that required us to really understand how connected cars work, how the mobility industry works. And I guess James is one of the leading experts. Now he's far surpassed me. I learned what I needed to know at the time using my generalist litigator skills. But that's true, obviously, and it has been for a while in health and in banking, COPPA. You need to have a foundation of knowledge of state privacy laws, data protection laws, data breach notification laws, rather. But as you get involved with particular industries, you need to understand how those industries work and what the particular privacy challenges are for them. And I think that's going to be a situation that will grow even further. And I can't believe we've gotten this far in the conversation without talking about AI.
That was going to be my next question.
Okay, I'll let you ask it.
Well, I mean, I think maybe to build on what you were just saying is it's not only understanding the industry, but also understanding the technology, as increasingly the technology and a really deep understanding of how that technology works and processes data becomes core to figuring out compliance strategies and kind of legal risk mitigation. Kind of interested on your perspective on that, because there's maybe no larger technological development that we've had over the course of the past 50 years than the dawn of the internet. And, you were at that point trying to understand how this all worked.
Right. And now we're at the dawn of another era that we're saying incredibly significant, it's incredibly risky, and that's AI. And so someone like you and your colleagues who are active in the day-to-day practice have to understand how the technology works. It's not just enough to understand what the current laws are or even the prospective laws. And at the same time, the regulators and legislators, I think, have to evidence what's been called regulatory humility and not to over-regulate at the inception of a technology that promises to, provide a lot of great benefits, as much of a risk or a threat as some people say it might be. The agreement that the major companies signed at the White House, I think it was last week, has some very high-level principles. It doesn't really get into the mechanics of how they operate their companies, but those principles are important. And so one of the things that's the hallmark, I think, of the Hogan Lovells practice, it's probably true elsewhere, is that the lawyers really stay up to breast on what's going on in privacy generally. There's so much information out there. There's so many treatises and blogs and podcasts where you can learn about this stuff. And you all do it in your spare time. I know I did it as well. I should put spare time in air quotes. But you have to if you're going to be a first-rate practitioner, as you are.
Yeah, I think for me, it's probably the first hour and a half of my day is spent learning about what happened in the prior day or what happened in the prior few hours. And that's one of the challenges and one of the really exciting things about this particular practice is that every day looks a little bit different than the day before, which is very different than some other legal disciplines where they have been doing the same type of legal skills and deploying that in the same cases over and over and over again.
This isn't like a 40-act practice, which people have been doing for decades. Not to demean the 40-act practice, but it's the reason I liked it so much, because it was just as challenging as a litigation practice without having judges or opposing counsel bother me in the middle of the night. Not to say that clients don't do that occasionally.
Yeah, maybe with that innovation and with that constant change, I think one of the areas that regulators and legislatures struggle with is trying to come up with strategies to enable the responsible uses of data with also trying to address the harms that inappropriate uses of data could create. Interested in your perspective as seeing a variety of different approaches during your career to addressing those things. Any advice to future legislatures who are thinking about trying to regulate data, regulate AI, or kind of the new technology that we're not even talking about today?
Well, there's been the development in the academy of literature that tries to describe privacy harms as extremely broad, would suggest that there ought to be particularly granular and perhaps overly broad regulation of those privacy harms. So I think the debate will be ongoing as to what truly constitutes a privacy harm that requires legal intervention. Particularly federal, if we start focusing again on federal privacy laws, you're going to have a discussion of that before you discuss what harms are you legislating for or against. And I think the lawyers who've been involved with this can play a significant role. And I think, again, there's a role for the Future Privacy Forum. We don't lobby, but we're often called upon because of our expertise to provide testimony. And there are also some friends in the academy, I think, that can be called on too to advocate for what I call regulatory humility. Again, not against regulation or laws protecting privacy, but also you don't want to kill the data baby in its infancy.
That's fair. One of the things that we're taping this in July 2023, and this also happens to be the time where recruiting season starts to happen with law students and law schools. And so I have a number of law students who are looking to understand, what privacy law is and what a career in privacy law looks like. Interested in your perspective on guidance that you would provide to future practitioners in this space.
So I go back to what I said previously. I think it applies to law students too. If they want to get into this area, read up on it and self-teach yourself, which is a lot of what you do in law school anyway. In the area of privacy, most law schools offer a fundamental course in privacy. Some offer many courses and get more specialized in it. And if law students can do that and take those courses, I think that gives them a leg up when they get into practice. But they ought to also come to the practice with an awareness that they've given themselves of what's going on. I suspect this podcast series will be helpful to them that they could listen to during their workouts or what have you. so they can come up to speed. But I think it's important to be up to speed. We used to take associates with no background. They didn't even know whether they had an interest. We had to convince them to stay in the practice. At Hogan Lovells, then, I don't know whether you still do, have a rotation system where people just try out a practice for a while. And we used to, have to sell people on it. Now people, I think, are really eager to get in. It's viewed as a very hot area, and I think appropriately so, because it's one of the most important areas of law in society right now, given how prevalent technology is in our lives.
I think that's totally right. In many ways, I think the younger generation of lawyers coming into the space have a lot to add as they understand, maybe than older generations, how people are using technology for both in the way that it's intended and, importantly, in the way that technology wasn't intended to be used. And that gives insight to our clients about how to manage those risks.
I would say that I found a real advantage to having had a career in counseling and litigation, mostly litigation, because I learned a lot about dispute resolution. And to a much greater degree now than earlier, dispute resolution and privacy go hand in hand. There are a lot of lawsuits. There are a lot of regulatory enforcement actions. So it would be helpful if students have at least some background in that. And once they get into practice, maybe they can do a pro bono case or two working as a team member on litigation, so they get a sense of what that's all about. Because I think bringing those skills to bear, you always want to be able to negotiate with your opposing counsel and with an arbitrator. And having those skills as a privacy lawyer is very, very useful.
Yeah. To circle on your other point around just how things are moving in this particular space, I think with change comes great opportunity. And, you have counseled me in the past, and I would say, Chris, this is not an area that I know a lot about. And you say, well, that's a brand new area. Nobody knows a lot about it. And so as a result, just go in and lean in and teach yourself. And I've learned that lesson many, many times during my career from you and from some of the other, people who created this practice.
And frankly, that's the most fun you can have in the law, I think, is when you tackle a new area and you become a subject matter expert in it, and then people recognize you for that and you have a business from it. I think there's nothing more satisfying as a lawyer.
That's terrific. Well, maybe that's a great place to end or to pause our conversation. But Chris, really appreciate your joining the podcast, sharing a little bit of your story and how you got into this particular space. And frankly, the role that you played, the critical first moments of the creation of the privacy bar.
I appreciate your asking me. It was fun talking with you as always. And thanks for having me today.